All right, it's 2 o'clock. I think we can go ahead and get started. Hello, everybody, and thank you so much for joining us today. My name is Katie Monahan, and I'm a communications strategist here at the Ohio Arts Council, and I am pleased to welcome you to today's webinar, The Business of Art, Legal Principles for Artists and Arts Organizations. So I'm going to introduce our presenters here in just a minute, but before we dive in, there are just a few housekeeping items that I need to go over. So first, everyone tuning in today is in listen-only mode. This just helps to cut down on any feedback issues during the presentation, but that doesn't mean that you have to stay silent. If you have a question at any point during the webinar, go ahead and drop it in your Q&A box there in your control panel. I'll be monitoring those throughout the webinar, and we'll take some time to kind of pause where natural to answer the questions, and we'll also leave plenty of time at the end to answer questions as well. If you have audio issues or trouble connecting, we recommend refreshing your browser, and if that doesn't work, try logging off and logging back into Zoom. And also please keep in mind that because we are presenting from our homes, there may be some slight variations in bandwidth or internet stability. So if the sound fluctuates or one of us freezes up a little bit, thank you in advance for bearing with us. I promise you we will keep on rolling right through. And finally, we are recording this webinar, and the captioned recording will be available on our webinars page at oac.ohio.gov/webinars and on our YouTube channel early next week. All right, I think that does it for housekeeping items. So now I'm really excited to introduce today's presenters, Jane D'Angelo and Stefan Thomas. Jane is the Executive Director of Ohio Dance, based here in Columbus, and Stefan is an Ohio Dance board member, a practicing attorney, and a performing artist. And they are here today to talk about, as the webinar title suggests, legal principles for artists and arts organizations. So everything from trademark and copyright to arts-centric agreements and the importance of having counsel, whether paid or pro bono, for your organization. So lots of really important information to go over today. So I am going to stop talking. I'm going to hand things off to Jane to get us started. So Jane, Stefan, thank you so much for being here. The floor is yours.
Hi, Katie. Thank you. And hello to all. Good afternoon. I'm going to introduce myself again, Jane D'Angelo. I have been the Executive Director of Ohio Dance since 2003. I have an extensive background in dance and dance education, and my degrees are in business and administration. And now I'd like to introduce Stefan Thomas.
Thanks, Jane. Thanks, Katie and OAC. This is going to be a good time. It's always difficult when you don't get to see people and really engage, but hopefully we're engaging nonetheless. Again, Stefan Thomas. I'm an attorney, professor, and performing artist, as Katie so lovingly referred to all of those items. From a attorney perspective, my primary practice areas are domestic and international business, litigation, and arts and entertainment, hence being here today. From a professorship perspective, I've had the pleasure of working, being an adjunct over at Otterbein University and Capital University Law School, where I focus on the music complex and on contract and IP matters. And then as a performing artist, I'm a singer-songwriter and performer as under the moniker T1. So thank you guys for having me and looking forward to more conversation.
Thank you. And I just want to let you know that you can check out music of T. Wong on Spotify. Ohio Dance inclusively supports the diverse and vibrant practice of dance of all cultures and for all capabilities. Ohio Dance advocates at every level of government and every community about the impact dance has on the state's economy, quality of life, and educational attainment. Ohio Dance presents the arts to the community through festivals, conferences, a virtual dance collection, performance opportunities, educational resources, networking, newsletters, and dance artist services. I want to start by stressing the importance of legal counsel for individuals and organizations. As a nonprofit, Ohio Dance has written into our code of regulations to have one lawyer and one accountant on our board. If you are a nonprofit organization, you might consider doing this as well. If you are just starting on your search for legal counsel, either as an individual artist or a nonprofit organization. Some resources you may consider are SCORE, S-C-O-R-E, and they provide confidential business advice through a network of 10,000 retired volunteer business experts. This is a national organization, and they have locations throughout Ohio. Currently, they are mentoring virtually, and you can check out their website at score.org. You also may want to reach out to college law schools to ask for recommendations for legal counsel. You could reach out to the Ohio State University, University of Cincinnati, Capital University, to name a few. Another avenue you could take would be to reach out to local law firms where you live to see if anyone might be available for counsel or at a reduced rate. And you could Google free legal aid and find resources depending on which region in the state you live. In a scenario, when you have required a lawyer, create an agreement with that individual. In general, whether you are an independent artist or a nonprofit, it is always good to draw up an agreement in any work you engage in. Many artists tell me they did not receive payment for work done, and then they share they did not have agreement ahead of time. You can create an agreement as simple as a one-page document to a many-page document. Make certain to include key elements such as dates, work required, hours, terms of payment, the amount to be paid, and when you would receive payment. There are websites that offer sample agreements, and I know that Stefan will add more to this in his discussion. When engaging legal counsel, draw an agreement that discusses the terms of whether the work will be pro bono or paid or a combination of both. For example, the lawyer may offer 20 hours of free legal service, and any hours thereafter may go to a fee. Make sure to indicate the fee structure so there are no surprises. The lawyer may be able to do a certain amount free, but involve the law firm for larger projects. There are many types of agreements and contracts, and I will go over a few. Employment agreements or work agreements for full-time, part-time, or independent contractors. You want to indicate terms of contract, whether it is an annual contract, then make certain to renew the contract within a year. For interns or volunteers, depending on what they are doing, you may want a confidentiality agreement, especially if you share passwords, and then plan to change passwords once the work is complete. Agreements at events with venues, not only price you will pay, but what is covered, such as cleaning, etc. Especially with COVID-19 and PPP, you want to find out who will pay for the cleaning supplies and do the cleanup. We have contracts with choreographers and teachers at events, and we ask that all participants, teachers, choreographers, and performers sign a publicity and injury release form, as well as a physical, mental, sexual abuse, and anti-bullying policy. Some insurance companies require these types of policies. We also have board agreements. New board members coming on have an agreement to sign, and board members also sign the physical, mental, sexual, and anti-bullying policy. And now I want to see, Katie, are there any questions out there for me?
Nothing so far, Jane, but I just wanted to remind everyone, feel free to drop questions in the Q&A box, and we'll just kind of keep monitoring those as they come in throughout.
Now I'd like to turn it over to Stefan.
Thanks, Jane. That always seems to move really quickly. So jumping into IP, I'll be going over some IP matters and also going over some contractual matters. So let's start with the intellectual property. So as a professor, I always prefer to start with basically the foundation of whatever we're discussing. So rather than getting into the weeds immediately, really trying to understand what we mean when we talk about IP or intellectual property. And so what we're talking about is essentially the creation of the mind. But more than that, it's it being embodied in some form or some fashion or some medium in a way that it can be protected. And we'll understand why that matters as we continue forward. But when you think about intellectual property, recognize that it spans pretty far, and it's a very complex area given that our society continues to advance in IP matters, technology, and things like that. So we can move on to the next slide. For the types and forms of intellectual property. So here we're talking about copyright and trademark because generally that's what people are really focused on, and that's what nonprofits are focused on. But I want to put a caveat out there to make it clear that there are multiple forms of intellectual property. You have domain, you have trade secrets, you have trade names, you have multiple different forms of intellectual property. And so we want to be mindful that when we think of it broadly and not just with these two areas. I'm going to ask to go back to that slide one more time. We jump back a slide. There we go. So focusing on copyright and trademark. So when you think about copyright, we're focused on the content. And when we're talking about trademark, we're focusing on brand awareness, okay? So with copyright, these are different forms of copyright. And so the way the copyright works, essentially you're gonna go to copyright.gov. And at copyright.gov, you're able to file for your particular protection. There are different forms for different, essentially art forms, since we're in this actual this webinar today. And I give some examples for the arts sector, but a lot of times you're looking at music, audiovisual, meaning works that are visual with audio accompaniment, pantomime and choreographic works. Obviously working with Ohio Dance, we're focused on a lot of that as well. And when we think about pantomime and choreographic works, we're thinking about a sequence of movement that have been captured uniquely. And you'll probably hear about some of the new dance moves that happen and kind of some lawsuits that have been around them, and they didn't quite win because there's still an expectation, there's still a standard there. So the great thing about copyright is that it's a very simplistic in its execution. And mainly because you have the ability to go directly to the copyright website, look at the forms. The forms are very good at description, and then from there move forward. And I believe we'll talk about a little bit more about that as we go. From a trademark perspective, we're looking at things like logos, slogans, motion, sounds. So when you hear the Netflix doom doom, and you hear the NBC and the ABC and the doom doom doom, all those different things, those are actually protected works. And if they're not protected, they're able to be protected. And so really what we're focused on here is brand association. And so what companies and individuals, because both can have trademark protection, what they are doing is trying to make sure that in commerce, there's no confusion as it relates to their particular brand, their particular product. So that's what we're focused on when we're looking at that side. So I really want to make that distinguishment between the two, because often in the art sector that I happen to run in, often we hear a conflation between the two, and they are very, very different. So just want to make sure that we understand collectively what those are. We can move on to the next slide. And Katie, if we have any questions, feel free to let me know. I know I kind of tend to move.
Yeah, we actually do have a few questions if this is an okay spot to pause. So I have two questions that kind of go back to what Jane was talking about at first. The first one was, Jane, could you mention again, there were several policies that you mentioned, the anti-bullying, I think one was sexual harassment. Can you mention what some of those other ones were?
So we have, so one policy we have is called physical, mental, sexual abuse. And then the other one is an anti-bullying policy. And then we also have a physical and injury release form. Now we have combined it when we do an event. We do ask everybody to sign something. We do a Google form that has everything combined, but they actually are three separate policies. And yeah, I guess
Okay.
that's about it. You know, I think that we found ours through our insurance company, provided some assistance with drawing those up. I think that you can also use Google to help with that, but if you have an insurance company that you work with, they might be able to assist you as well.
Great, thank you. And then this one kind of tracks a little bit along both of those lines. So this could be either for Jane or for Stefan. Somebody's asking about safety-wise. Is it safe to use legal forms that you find on the internet? I think this is outside of the copyright site that you mentioned, Stefan. Obviously, those are legit, but do you have advice on that question?
That's a great question. Whether it's safe or not it's really based on the person's or entity's risk tolerance. So some people, are comfortable, just kind of snatching and running. Some people are not. So I can't say that it's more safe. What I can say is that it's often important that you're utilizing a form, whether it's a form that's been built for you or one that you find that actually fits the needs of your particular art or your particular organization or the task at hand. What I have seen in the past is that people are using either form agreements from attorneys or from the internet. And because of nuances in the way that they operate, we kind of miss the mark in certain areas, and it kind of leaves a greater level of exposure. So it's completely up to you. I try very hard not to be biased against one way or the other because, some of these entities are doing a very good job and doing a great service to individuals who require a certain amount of access. So it's completely up to you. You just want to make sure that it really fits your needs. I'm happy to talk more about that later. But, just be careful there. And for the copyright website, we'll talk a little bit more about that here. But when we're thinking about the copyright website, they're going to be providing forms for the actual protection themselves. So you're not going to be able to find any contracts on there unless maybe you're reading through the copyright code and, find some information that's helpful. Great question.
All right, great. I think that's it for now. We'll keep on going.
Great. All right. So filing. So trying to give you something with a little bit of teeth, right? So from a copyright perspective, again, going to say that website, copyright.gov, this is where you're going to go in order to establish and submit your filings. You're going to create an eco registration portal profile. And so that allows you to do most things digital. The Copyright Office is doing really good with digital access, but there are still some things that have to be done physical. So you have to pay attention again to your particular art form or the art form that's being produced on your behalf, okay? So there are 3 different types of filings on the copyright side. You have pre-registration, you have unpublished, and you have published. They all essentially have their own different levels of protection that they offer, and they all also have different requirements when it comes to the filings themselves, meaning if you have to deposit an accurate copy of your work and things like that. They also will provide you have to pay different fees for each, okay? So for pre-registration, it's really focused on those art forms that tend to have more infractions, or those that are being, copied, essentially, trying to say it as simple as possible. So think of, movies and things like that, where people tend to really kind of snatch those and run with them. That's where you'll see a lot of pre-registration. And so there are a few different requirements in order to file the pre-registration, including it being unpublished, but it's definitely a good place to go if you are practicing in an art form that is essentially highly coveted. From an unpublished perspective, it means that you haven't went to commerce with it yet, okay? Commerce, essentially what we're talking about is selling any form of distribution, transferring it over to another entity or company in order for it to be released to the public. Think essentially about it being transferred for the use of the public or for viewership of the public. That's when we're talking about unpublished. And then finally, you have your published, which means we have moved forward. We've sold our first copy. We've signed a transfer or an assignment agreement to allow another agency or entity to release on our behalf or anything like that. The big thing here that we're focused on between unpublished and published is really that right of first publication. That's really where the big conundrum is. We, as far as the government is concerned, are still focused on making sure that creatives still have the first right to release their art form. So you want to pay attention there. When you're thinking about fees, you're going to be ranging around $45 to about $125 in filing. So pay close attention again to the forms. There is a particular form and fee document that the Copyright Office keeps on file. So you can simply go and look at the FAQs and it'll give you that information. And a lot of it will, again, depend upon whether or not you're going to file online or whether you have to do something physical. Also of note is group filings. Often I hear a lot about that, especially from my visual artists and musicians who, are making multiple songs or taking multiple photos or things like that. A good rule of thumb is if you can, you want to group your filings if they're in a collective work. And the reason is for each filing you do, you have to pay a different fee. So if you're, the easiest example is if you're a musician or if you're working with musicians and they're creating a work product, if there's 10 songs, you really want to protect those 10 songs together. You want to refrain from going each song and protecting each song individually, only in the sense that you don't want to invest your monies in that way. The fun part about the Copyright Office is that they're generally pretty helpful in answering questions about the filings. So you can call, speak to them if you've made a mistake in the filing but already submitted. They're often able to help you on the back end. So you really can have a good time with the Copyright Office, okay? You can also engage a professional or a lawyer to assist you with it, but you can do that on your own, generally without too many disruptions to the way you operate. On the trademark side, I make that distinction because on the trademark side, it's a little bit more intense. With the trademark, you're going to uspto.gov. uspto.gov, and that stands for United States Patent and Trademark Office. And that's where you're going to do filings there. So that particular URL allows you to file patent protections and trademark protections. I do not speak on patent because I am not licensed to be a patent attorney, and I'm not taking the bar again to be a patent attorney, okay? But happy to assist with directing you to different patent attorneys in the city and around. So just like with copyright, there are multiple filings. We are going to speak on two of them just for ease. The one is the 1B, which is the intent to use, and the other is 1A, which is you're using it. So for your brand, whether it's a logo, a slogan, a sound, whatever the case may be, some entities and some individuals really have a concern that their mark, and that's what we call it all, their mark is going to be infringed upon. Whether it's because you've seen it out on the market recently, or you've seen something similar, or you've maybe shared it a lot more than what you intended to, there becomes some apprehension that it's going to be utilized. And so what you're doing by doing this intent to use is really putting the world and the Copyright Office on notice that you intend to use this within a specific period of time. So it means maybe within the next 6 months with some extensions, several extensions to allow you to get the mark up and running in the market so you can prove to the USPTO that you've actually been using it in commerce, okay? On the other side, there's the use, which means that you've already used it, you've already provided your service, you've already sold your product, anything like that. And so now you're saying to the USPTO that I have basically specimen or examples of the way that I've utilized my mark in the marketplace, and I want to protect it so that I can protect my brand awareness, right? So that's where you're focused there. A good rule of thumb here is that if you do an intent to use, you will have to move into a use application. So don't forget that. Once you have actually used it, you'll need to go back in and file the appropriate paperwork so you can get the ultimate protections that are provided. What we're focused on here, copyright, we're focused on creativity, original authorship, which there are several categories for original authorship that we don't have time to go through today. But what we're focused on the trademark side is really strength and creativity in the mark. So we want to make sure that there's no confusion in the marketplace. So me and Jane can't both have the mark glasses. I know we're both wearing our glasses today, and expect there not to be some confusion in the marketplace. So you'll look at, the area that it's being utilized in, the way that it's being utilized. On the other side, we have to be creative. And what we call kind of the best one is fanciful. So the most fanciful mark, the one that kind of comes out of, nowhere, thin air. So you want to pay attention to those when you're creating and developing your brand. It's a really good conversation to have before you fixate your particular brand on a particular mark. because you really don't want to have to undo that from an economic perspective. It can be a headache, okay? So there's a lot more, but we're running low on time. Katie, are there any questions? If not, I'll jump right into the next section.
No, I think you're good to keep going.
Great. And so jumping into the contract world. So this is where it gets, I think, a little juicy. But with the contract world, what I have found in practice and in my time consulting these are some of the contracts that I believe that really every arts agency, entity, individual should have in their arsenal. So that question about whether or not you utilize something off of the internet versus something for yourselves, oftentimes in this area when I'm out facilitating, we talk about something called form agreements. And so that's really partnering with a firm or a lawyer that really understands what you have going on and really establishing a core set of contracts. And that way you're able to reutilize those contracts over and over again, maybe without necessarily having your attorney always present, and things like that, okay? So these 4 agreements I have seen utilized in the art space across the board and generally all art firms that I've had the privilege to be involved in. So confidentiality agreements or NDAs, known as non-disclosure agreements, your waivers and your releases, which Jane mentioned briefly, license, and your independent contractor agreements. So they're in a particular order kind of for a reason. So from a confidentiality perspective, really at the outset of your relationships, of your business relationships, this is where this agreement really comes in place. It can come in place for the purposes of determining whether or not there's going to be a partner or business relationship, or it can come in place simply to share an idea with a subset of individuals or entities that are going to help support the venture. The good thing about the confidentiality agreement is that it gives the confidence that you can share without explicitly being, ripped off, and without some type of mechanism to protect. As with any agreement, it operates as a sword and a shield. So from a sword perspective, if someone decides to take your brilliant creative idea and it's been properly protected, then you can use this confidentiality to go to the courts or go to wherever you've agreed to arbitrate or litigate. And you can actually say, listen, we were under protection. They knew they weren't supposed to use this. I'm going to enforce this against you so we can get these protection back, get whatever our damages are, etc. Okay. In this agreement, you're looking at defining the relationship really clearly so that it's known that this is not a joint venture situation and that we're not quite partners yet, unless you are at that stage and you're putting in some heavy confidentiality provisions for the purposes of your relationship. You want to clarify the responsibilities. And what is that talking about? So how do you manage and maintain the actual shared information? Where is it going to be housed? How is it going to be housed? When is it deleted? All those type of things. When is it turned back over? That's what we're talking about. And then what work is going to be protected and the different terms that are going to be connected in that. Okay, so you really want to be very clear in that. And generally, all art forms deserve to be protected, okay? And what I didn't mention previously was that at common law, both trademark and copyright exist for your protection or already protected once you created them and put them in the right medium. What we were just talking about was federal protection. I just want to make sure that it's very clear. Federal protection is the widest protection in the United States, not necessarily overseas. So you want to pay attention if you're a global operation on how you're going to protect abroad. But common law assists only so much, and it's very technical, and so you can definitely talk to a lawyer about a professional who understands copyright a little bit more to go deeper into that, okay? So moving on to waiver and release. Waiver and release, it comes in many forms. If you're a choreographer, or if you're a dance studio, or if you're a videographer, or anything like that, where you're bringing on extra people to volunteer or to engage. If you're a playwright and you have a bunch of actors, things like that, you'll see a waiver and release when you're trying to release liability. So, if things get stolen while on set, you don't want to be responsible for that. Or if someone unfortunately tweaks an ankle or a muscle, you really want to try to avoid the responsibility as much as possible when we're all coming together as a team to create a final product. So it's really to give everyone kind of this relief that in coming in and cooperating together, we're going to be able to create together without really being stressed about somebody attacking every time something goes slightly wrong. So again, it relieves the liability from that aspect, either financial and sometimes legally. From the scope of time and the scope of use, you're able to identify how long the waiver is going to be in effect, why it's going to be in effect, what particularly we are waiving, those type of things. And sometimes you can even include compensation clauses if it's appropriate for that particular release. Okay. So then we have a license, which is something that I don't hear enough about in the arts world, that I think really deserves highlighting, because the license is where you really get to monetize your product. So from the perspective of letting people use it or letting other agencies borrow it, or using it for, a commercial or a spot or things like that, this is where the license comes in handy. This is where you get to tell the end user, this is how you can use my work, and for how long you can use my work, and for how much you can use my work. It's very important to brands that have a strong underlying tone. So whether it's a religious tone, or whether it's a maybe a familial tone, maybe, proponents of advocates against child abuse or elder abuse, things like that. The reason why this becomes very important in those instances is because in the instance that your end user is inappropriately using the mark, or they get in trouble for something that the brand doesn't stand for, this is what you would be able to utilize to sever those ties and prevent people or entities from continuing to use that. It's also on the flip side. If you want to borrow someone's work or introduce someone's work into your own work, a license is going to be one of the most proper mechanisms to do that. So you want to talk about the rights of use, where we can use it, how we can use it. You want to limit the user's usage. So if you don't want it to be used on a YouTube clip, then you need to identify that. If you don't want it to be used on the side of cigarette cartons, then you have to identify that. And then, of course, one of the most important things that I think people miss is the life. How long does this license exist? Is it for 3 months? Is it for the duration of the collaboration, or longer? And then, of course, revenue. How much are we talking about? Is this gratuitous, or are we making $1 million off of this collaboration, or what's happening? So license is really, really important, especially for those of you who are creating work product. It's extremely, extremely important. And then finally, the independent contractor agreement. Often I see in every art form, there is some type of collaborative effort. So someone is engaging someone else to come in, or some entity is engaging someone else to come in to provide a particular service that they cannot do, or they have chosen to outsource. So here is where we're going to talk about the extent of that business relationship. A key thing to know here is, just because it says independent contractor agreement does not mean that it's necessarily independent contractor. So you want to be careful at how you control the relationship, and kind of, how you finance the relationship, and some other things that the courts will look at to determine really if it's an employment relationship. And I bring that up because if it is really an employment relationship, then you'll be subject to employment law, you'll be subject to certain taxes and other financial restrictions. So you really want to pay attention to the liability that's associated with that. And this is where I would say, especially with the independent contractor world, depending on how many you have on board and all that type of thing, you really do want to probably have a conversation with an attorney to make sure that you're structuring the relationship right, let alone the actual agreement. So from an agreement perspective, you want to talk about the scope of services, what work is being done, how long is it being done, etc. Milestones are important depending on, well, always, but really depending on financing. So if it's a big budget, both parties can really benefit from bracketing out the milestones at which payment will occur. And Jane had mentioned payments and making sure that you know when you're getting paid, things like that. This is a really good way to do that, to know if there's 10 steps to this project, that the creative or whoever the collaborator is, that they'll be getting paid at these particular instances if it's not going to be done hourly or some other way. Then, of course, from an independent contractor agreement, key is understanding expenses, payment, and taxes. You really want to be clear on who's responsible for each and what that looks like for each, okay? That, again, have some bearing on the independent contractor versus employment relationship. And then you want to talk about the project itself, being very clear about the relationship, what it is that we're doing. Is it for charity? Is it, is it for some other purpose? Things like that. That's where you can really describe what's happening. So, of course, as Jane said, these can be one pagers, if I saw a one-page independent contractor agreement, I might look questionable, but it could be size 8 font with a lot of great detail in it with double columns. I don't know. But they can also, as Jane said, have multiple pages. It's really up to you. It's about the quality, not the quantity, so to speak. So please don't feel overwhelmed when you're getting your contracts in place. Really look to it as a great investment for protecting your company, protecting your individual art form, and protecting the work product that you're putting out into the world as creatives and conduits for creatives and of creatives. Are there any questions for me there, Katie? If not, I'll move to my last slide.
No, I think you can keep going. And then just another reminder to folks, if you do have a question, go ahead and use the Q&A box, and we'll be tracking those.
Great. So finally, for my side of the discussion, just some impactful issues to keep in mind as you are exercising in the arts sector. So tech distribution and global interactivity. From a tech perspective, it's really important to know, especially now, people probably see it more than ever because of COVID-19, all of the remote working and things like that. Technology actually enhances the copyright and trademark issues that we have, generally speaking. There's an example of a university that I conferenced with not too long ago who had a great question about essentially airing their what are normally kind of orchestra performances for university purposes through Zoom or through other mechanisms. And the issue that we were having there was then we were moving into performance space, which unfortunately requires its own license. And so you have to really deal with those teams, those camps, whoever has created, the composers who have dealt with those things. So technology and the investment of it actually causes those type of issues. And you really don't want to find yourself on the back foot because you're moving fluidly, either based off of what somebody else has done or just because of just lack of knowledge. So really paying attention to the advancement of technology. As I teach in all my classes, as I spoke this morning to my class, technology it enhances, but it also prohibits and it also alters art forms extremely. And so there's always this song and dance between art and technology. And you always want to pay attention to what's happening with technology. Generally, legal, government are lagging on trying to protect the art forms and technology. So you really want to pay attention. If you have advocates or if you're an agency that advocates for arts and technology, you really want to pay attention to those protections there. From a distribution perspective, distribution has completely changed. A lot of it has gone online, which means we're losing our brick and mortars or our physical distribution, but that also means that there's a lot more movement. And again, your copyright and contracts are going to be really pivotal there. And the return of rights from those relationships, really paying attention how the rights come back, what that really looks like, and earmarking correctly, and paying attention to the cost. The costs are a little bit different to be online than they are to be in a warehouse, right? So paying attention to that and not being sideswiped. Finally, global interactivity. Because of technology, again, we're able to communicate across boards the way that we kind of weren't able to before, because of, again, because of the video technology, telephonic technology, we're able to talk or share or sing across and all those things. But what does that mean? That means generally we're sharing artistic content and we're sharing brand awareness across borders. And so we really want to pay attention to what that means in that particular territory as far as protection, as far as recovering financially, and things of that matter. Again, copyright and trademark do not necessarily expand. We do have sister treatises and you can pay attention to those, but often you're going to have to go into that territory, not necessarily physically, but go into that territory in order to build up the proper protections. And then of course, you want to have some great intercultural communications when you're dealing with the cross-border communications in this environment. So hopefully you've learned something. If not, thank you for your time anyway. Thanks, Katie.
Thank you, Stefan. I think we're going to toss it back to Jane here to finish us up.
Yeah, I did want to mention that Stefan was instrumental. Ohio Dance wanted to trademark their name of the virtual dance collection. And so we reached out to Stefan to help us with that. And it was a process. It was a long, it wasn't too long because I think we started in April 2020. and it came back, I forget exactly when it was trademarked, but sometime in the winter, I guess. It was a great process. I learned a lot. I still don't understand everything, but luckily I had Stefan and his law firm to help me. So for something like that, you definitely want to have legal advice, because I would not have understood it. But we worked with the board to discuss the terms and the different ways that we were going to trademark the website, whether we included some of our additional work that we do, a textbook and things like that. So we had a lot of discussions back and forth. I learned some new legal terms that I didn't know about before, and happy to say that right now we have a trademark for, well, we started with a just the trademark, but now we have the registered trademark. And there's something about that. It's I forget what it's called, but we have to go into another process after that in a few years. We take it to a new process. I don't know if you want to mention something about that, Stefan, or.
So, and thanks, Jane. So with their particular process, it did get really technical because, and again, we're at 53 minutes, so I won't go too crazy with it. Essentially, when it comes to the trademark process and the Copyright Office process, really what you have are the opportunity for someone on the other side, specifically for the trademark, a lawyer on the other side, to tell you whether or not they agree that this mark is protectable. And it could be because of the strength, or because of the creativity, or because of confusion, or any reason that is listed in the code. So you want to pay attention. And so with Ohio Dance Virtual Dance Collection, there were a few items in there that the actual examining attorney was concerned about. And so we were able to reach an agreement to make sure that Ohio Dance still got the protected trademark as long as they continue to use it a particular way within a particular scope of time, and then it would flip into the basically a full outright protection. So there are different levels of protection, and we are basically on our path to the final and full protection here shortly. So again, having an attorney for the trademark process really does come in handy. As Jane said, it can be really technical. Both of them are technical, but the trademark process can be really technical. In order to really get that protection, it does sometimes take a little more legal knowledge to be able to really persuade essentially the United States that the mark does belong to you or your organization. And Jane and the executive committee, and they all did very well with staying very diligent and providing really, really great opinions and being able to come to a resolution with the United States, because that's really who you're negotiating with. And also, as last note, if you do have to appeal a decision, just remember that you generally will have to pay yourself for those items. And none of the fees are refundable. So, it is worth, the investment either of your time or your finances, and really doing it the correct way as best as you can. So thanks for catching that, Jane. Sorry about that.
Oh, thank you. Yeah, it was great. Yeah, obviously, with any of the agreements I spoke about, it's always good to have legal counsel in any way you can, shape or form. It's much better to do it that way than just going off the internet. But I just want to also thank all our funders, and of course the Ohio Arts Council is one of those funders. And now my email is here, so if you want, you can reach out to me. And I guess, are there any other questions, Katie, that people had?
Yeah, so first off, thank you both. That was an incredibly informative presentation. I was telling Jane and Stefan both that when we did our little dry run for this, I was blown away, finally understanding the difference between copyright and trademark. Thank you, Stefan, that was great. So we do have quite a few questions, so I'm gonna go ahead and start asking them. Either one of you feel free to pop in and answer. Again, if you do have questions, you can drop them in the Q&A box and we will get to them. So first off, there are a lot of questions about templates and examples for contracts. Where can we find examples of independent contractor agreements? Are there credible resources for contract templates out there? Would either one of you want to speak to those?
Jane, where did the board initially, where did you pull the contracts from, or was it from the original attorney, or what?
From the original attorney, yeah. So we had one drawn up by an attorney, and then I had you review them afterward just to make sure they were current, which is a good practice. So I really do feel certain contracts you really might need to either spend the money to do it, or like some of those free resources I mentioned with SCORE, and maybe one of those attorneys could help you. I think it's something that's really valuable if you're dealing with employment. That's something you really need to spend money on. You know, I think some of the other agreements, like a publicity release form, is more simple. You might be able to find samples when you Google, but there are certain things that you really do need to get professional help with.
And I didn't prompt Jane to say that, so don't think that we're a tag teaming. No, I unfortunately do not have any sources that I can say are credible or not credible. As generally, I'm focused on drafting them, so I just am not looking up in any particular resource. As Jane said, I think definitely a great practice is if you do decide to move forward with a Google or a Yahoo search or whatever the search is out there right now, you just want to pay attention to the possibility of having counsel to follow up behind it to make sure that it works. I think that was a great suggestion, but unfortunately, no, I don't have any. And I think Jane gave some great resources to try to find some of those that may be more available.
Great. So it sounds like definitely, you know, contact an expert before you just use some random form. But after you, you know, consult with an expert and have that first contract established, then it's probably safer to use that as a template moving forward once you've kind of established that.
Yeah.
Right?
Doing the form agreements is really a healthy budgetary way of kind of building that arsenal, and especially if you have repeat practices. So if you're constantly engaging, in licensing act practices, really having a good licensing there, it's a lot easier to maneuver the language and negotiate if you have a solid foundation versus trying to start from scratch every time or trying to pull language from different places. And I have seen that where people try to pull language from different contracts, and I will tell you that it has not been successful in the instances that I have seen it, meaning that it has caused problems in the business relationship in the end, because most of the time it just doesn't make any sense. So oftentimes, as Jane said, the investment is in just getting the know-how from the attorney. If the attorney is educating the client on what the terms mean and what the impact of each provision is, it really becomes more useful than simply snatching and going, because it really doesn't matter if you don't really know what the language means, so it could really be helpful. So yes, Katie, that I agree absolutely with that. Get something in place and then you can play with that. That's the whole purpose. You really have something you're more comfortable with and can go from there.
Great. Yeah, so it's worth making the investment up front rather than fixing a costly mistake later.
Always, always.
Great, thank you. So next question, how do I find an intellectual property attorney with experience helping visual artists protect their property with licensing and copyright? It's a niche experience that I find many lawyers don't have.
That's a great question. So really going to centers of influence. So OAC, Ohio Dance, different agencies that are connected with different wheelhouses. GCAC is a good place. They generally have kind of pools of referral sources. You can also check your local business bar association. So if you're in Columbus, the Columbus Bar Association, or if you're in Cincinnati, the Cincinnati Bar Association, or you can check the statewide association. And oftentimes it's really going to be a fit conversation. You'll maybe get a list of 5 or 10, and it may be a little bit exhausting, but it'll be worth your while if you've had a conference with those attorneys and you really feel like you've gelled with an attorney and they really get what you're doing, or you really want to build with those attorneys or that attorney. So bar associations are always great, and centers are always good, those who have those referral connections.
Great, thank you. And this one's just a comment. There were quite a few comments when Jane was talking earlier about some of those agreements that they've had, but someone just commented, I'd really love to see the language around that anti-bullying/harassment policy. I think that's an important one too. So
I will say, I'm working with Dance USA right now, and we're working on a statement on physical sexual abuse and anti-bullying, and that we will make that public soon. So we're looking to make that public by hopefully May. And so that would be some language that people might be able to use once we work on the language, the finalized documents. So I'll be sending that out. So you can check out our email. It's free, and get on there, and then we can share that with you at some point when it's available.
That's fantastic. Look forward to seeing that. So, I think that is it, unless anyone else has any other questions. Last call for questions if anyone wants to ask. Otherwise, is there anything that either of the two of you would like to add that maybe we skipped over or we didn't get to before we go?
I don't think so. I mean, you're welcome to email me as well. My name, I am Stefan at tilawgroup.com. I mean, there's a lot that we could discuss, but I think we tried to hit very, very high level. Other than that, you guys, thank you for your time.
Yeah, thank you both so much. Again, this was incredibly informative. And I just wanted to remind everybody that the recording of this will be available early next week on our webinars page. Again, that's oac.ohio.gov/webinars. So you'll be able to find that there. And other than that, that's it for today. Huge thanks again to Jane and Stefan. We really appreciate it. And thank you to everyone for tuning in today. And we will see you next time. Have a good rest of your day.